Please be seated. We will hear argument in 230927, Cromwell against Anadarko E&P Onshore.
Court, Mr. Smith will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors. Mr. Cromwell's leases require production in paying quantities, and it is undisputed that such production has occurred at all relevant times. His leases have not expired. There are 2 points that I would like to address this morning. The first is the rule of Anadarko v. Thompson as applied to the plain text of Mr. Cromwell's leases. And the second has to do with the 3 things that Anadarko says Mr. Cromwell should have done in order to sustain his leases, drill, pool, or JOA, and why those are neither practical nor textual requirements to impose into the lease.
Why, on that second one, why isn't by the lessee superfluous if the lease binds the party charged to produce?
Your Honor, the lease does not bind the party to produce. It requires the existence of production, and that can be seen by the very fact that the lease has a pooling clause that allows for joint pooling of different leases. And so it's contemplated that there will be production, not necessarily production by the lessee. And
So obtained production could mean you produce, or you have someone else in your stead produce?
Or production is happening from the acreage covered by the lease. And so that's what has undisputedly happened here.
And here there was contributions to the costs and expenses of production. Is it your position that if there had been no contributions made or efforts made to participate in the expenses associated with production, could a co-tenant secure the lease simply by pointing to another co-tenant who was producing, whether or not the co-tenant has participated in the production?
The answer to that question is yes. And here, Mr. Cromwell went above and beyond what was required in order to sustain the lease. And I think
But we don't need to decide that for you to win this case, right? Because your client contributed to the cost of production. And so if that's enough, then we don't need to decide what would happen if there were a co-tenant who had not contributed to the cost of production, right?
Well, that's correct, Your Honor, and we're happy to accept a victory under either path to the decision tree. But I think for the sake of stability to the oil and gas industry in general, and for Mr. Cromwell under further operations under the lease, how does this need to work? There should be guidance as to the proper way for these leases to be sustained. It's important to distinguish between the covenants in the lease and the conditions in the lease. And I think this goes to your question, Justice Bland, about there being references in the lease to production or drilling activities by the lessee. We see that in the continuous operations or continuous development clauses. If production ceases, passive voice, then of course there is an expectation that the lessee will take additional steps to secure production if it's lapsed. But when there is already production, it makes perfect sense for it not to require duplicative, redundant wells, unnecessary steps, when the purpose of the lease is already being obtained.
So in this case, where your client executed the lease after there was ongoing production, there had been development, there was ongoing production on the lease, does that production suffice, or is there a requirement that under the new lease and those lease terms there be some new development that leads to production?
The lease does not require additional production. It requires, or additional wells to produce. It does require ongoing production, so additional molecules coming up out of the ground, and that's what has undisputedly happened throughout the entirety of Mr. Cromwell's leases. So that has happened, and he's gone above and beyond by contributing to the costs of pooling those hydrocarbons out of the ground. His leases have been perpetuated.
So your answer to the other side's positions is simply that the solution is not a top lease. The solution is to seek contribution from a co-tenant toward the expenses of production.
I see Anadarko's concerns as being a gripe about the common law of co-tenancy, and what they want is they're a stranger to Mr. Cromwell's lease with his lessors, and they want his lease with his lessors to be construed as favorably as possible to the co-tenant. That's not a rule of lease construction. The rule of lease construction is it does not terminate unless it is clear, precise, and unequivocal. That's what Anadarko v. Thompson held. And we provided in the bench exhibits, tab A, I think is helpful. Anadarko's statements 20 years ago to this court, page 7 of their brief, where they say, in a misguided attempt to effectuate what the Court of Appeals assumed the intention of the parties to be, it violated this court's directive to give their leases their plain grammatical meaning. That's the way to achieve the purpose of the lease, is to look at what the text says and what the plain grammatical meaning is. And achieving production, what Anadarko and what the Court of Appeals presumed the unqualified purpose of the lease to be, it's not an on-off switch, an either-or proposition where every failure to take another step to secure production results in the death penalty of giving up the lease. It's more like a dial where the parties can choose the best way to secure production, and they can negotiate the best way to negotiate production on the facts of their lease.
Right, but you agree then that if that production is securing the lease and you're benefiting from that production, then your co-tenant could have a claim for expenses associated with it against you.
Under Cox v. Davison, yes, there's the netting out where when they contribute, when they net out revenues that Anadarko's producing Mr. Cromwell's molecules and profiting off of Mr. Cromwell's hydrocarbons. And as they are doing that, they have to contribute to him his share less his proportionate costs of producing those molecules. And so that gets netted out in a co-tenancy relationship. He's gone above and beyond, not just by letting them net it out, but by affirmatively sending checks in advance before the value has been obtained, before production has been secured. And reading the phrase by the lessee into the habendum clause, where it's not there, does violence to the negotiated way in which the parties wanted to secure production on their lease. And I think Anadarko emphasizes the treatises. I would point the court to section 503 of Williams and Myers, and we cited it in our reply brief. And the Williams and Myers treatise talks about an old Oklahoma case where the court distinguished between a clause that required by the lessee and a clause that did not require by the lessee. And the Williams and Myers treatise says you give that distinction effect. If they choose not to include that in the lease, you don't imply it back into the text. I'll quote it. The Williams and Myers says, presumably, if they in the lease, if they had said by the lessee, if that had been there, then the interest of the lessee would not have terminated at the expiration of the primary term, but because those words were in that particular lease, it did. Here we've got the opposite. We follow the text. That's what the treatises say. That's what Anadarko v. Thompson held. That's why we have amici such as Chevron saying we're in the position in some cases of Anadarko. We're in the position in other cases of Mr. Cromwell. We need a stable rule so that we could know how to maintain the leases, so that we could know what title is on the ground and who owns what.
Counsel, you say that Anadarko is a stranger to these leases. Does the record reflect anything about who drafted the Ferrer and Tantalo leases and whether there was active negotiation about the use of the passive voice for the habendum clause?
The record does not disclose the history of those negotiations, but I think it's useful to contrast Mr. Cromwell's leases with his lessors and Anadarko's top leases, because Mr. Cromwell's leases were actually more favorable to the lessors than the leases that Anadarko took out on top of that acreage. And the notion that you would imply a termination into Mr. Cromwell's leases to further the purpose of the lease so that the lessors can have a worse deal is contrary to every rule of construction. And I'd point the court to Section 18 and Section 12. Section 18 of the original Tantalo lease, and then Section 12 of Anadarko's top lease. And you will see that Mr. Cromwell had rather emphatic indemnity obligations to his lessors. Then, when Anadarko comes and takes the top lease, it flips the board and caps its liability with a waiver of liability. And the same thing goes with the benefits obtaining to the lessors under the lease. If the court looks at the bottom of page 2 of Mr. Cromwell's original lease, you will see that there is a shut-in royalty clause where there's an obligation to pay, or a condition to pay, $25 a mineral acre for if a shut-in condition occurs. If you then look at Section 3 of Anadarko's Tantalo lease, it's very hard to read, but about the 12th line up, Anadarko negotiated a shut-in royalty that is 1/25 of the amount that Mr. Cromwell had under his lease, $1 a mineral acre. And so the notion that you've got to burn the village to save it, to terminate the lease, to accomplish the purpose of the lease, it is upside down, and it puts the lessors in a worse spot than they would have been if the plain text of the agreement with Mr. Cromwell had been maintained.
I think we understand your point on that, but I want to be sure you get to the point that you were going to make about, well, why couldn't Mr. Cromwell assign or pool or enter our JOA and deal with the situation that
Correct.
way?
With respect to pooling, at tab B of the bench exhibits, we've provided an excerpt from the statute regarding compulsory pooling and then the treatise discussing it. And compulsory pooling is not possible. It is not legally permitted when you don't have ownership of separate tracts.
Because this is an undivided mineral interest.
Correct, Your Honor. And so the purpose of pooling is to cause everyone to share interest across the acreage. That's what this court just held in the ConocoPhillips versus Hahn case. And you're already there when you have a co-tenancy. They're already sharing undivided interest across the entire acreage such that production on one point is attributable to the whole. If you have a joint tenancy, pooling is unnecessary and it's not legally available for compulsory pooling. As far as a JOA, joint operating agreements are not even mentioned in Mr. Cromwell's leases. And the purpose of the joint operating agreement is to allocate the rights and responsibilities among the co-tenants, not between the lessee and lessor. It's between the co-tenants. In the Talls versus Barnes case that this court decided back in 2011, the court held that the lessor isn't even a third-party beneficiary of the JOA. The lessor can't enforce the JOA. This is between the co-tenants. And
does it just alter what the common law rules would be as far as if you're a co-tenant without a JOA, as Justice Bland was asking you, your co-tenant may be able to sue you to get, if you haven't been paying your share of the cost of production and that sort of thing. And so does the JOA just replace the common law rules?
it changes it from a netting out situation where the co-tenant doesn't pay you until it has recouped your proportionate share to an affirmative contractual relationship to pitch in and contribute to the production. And that's what Mr. Cromwell was already doing here. The point I would especially like to make with respect to a JOA is that the court shouldn't read a condition into the lease that's not there that would give the co-tenant, the stranger to the lease, the King's X, the ability to vaporize and terminate the competitor or the co-tenant's interests by withholding the joint operating agreement. Mr. Cromwell went to Anadarko asking for a JOA multiple times. They never provided one to him. And when his lease between he and his lessor doesn't require him to go do that, The fact that Anadarko prevented him from doing so shouldn't cause the termination of his lease.
Does your position effectively require Madison to be overruled? And I realize you say, oh, that's just an eerie guess, but it's a case that's been around 65 years, and so there's been some reliance there.
I think there are two answers to that, Justice Huddle. One, it does show that Madison is incorrect, and Madison says, quote, that the prime consideration in drilling is drilling, or in the lease is production by the lessee. If the court looks at section 1 of each of the leases, the court will see what the parties actually agreed the consideration to be. It was the payment of royalties, the payment of bonus, and the covenants that give rise to duties rather than conditions that were the consideration. We ask this court to reverse.
Any further questions?
Just one more before you sit down. Can you help me in the Tantalo lease? How do paragraph 16, paragraph 11, paragraph 6, they all kind of make cross-references to one another, that they're all subject to one another? Can you just hum a few bars on that?
Yes, Your Honor. Paragraph 11 is the key clause because it is written in the passive voice. It does not require production by the lessee. Now, there is the separate paragraph 16 that uses words by the lessee. I think that shows the parties knew how to impose that requirement when they wanted to. But that section says it's subject to paragraph 11. Now, it's a little peculiar because section 11 says it's subject to section 16. I think the way you resolve that conflict is by the clear, precise, and unequivocal rule, and you construe it against termination. Thank you.
Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Samora will present argument for the respondent.
Mr. Cromwell asked this court to hold that the typical oil and gas lease can be used as a mere passive investment tool. He argues that one like himself who took an oil and gas lease from a mineral interest owner and who had no intent to and never did drill a well or explore for or produce oil and gas can maintain that lease indefinitely past the primary term based solely on prior production by a co-tenant.
So the habendum clause doesn't require drilling or exploration, it just requires production, right?
The habendum clause does not expressly require it, but it immediately follows the granting clause. The granting clause, if we provided the court with...
But what you're arguing has been violated and caused the lease to lapse was the habendum clause, right?
We're arguing that by not producing oil and gas, and actually this goes back 100 years to this court's decision in Texas Company versus Davis, where the court construed the granting language in an oil and gas lease. And
Okay, but do you concede that if we just focus on producing and we don't focus on development or exploration, you lose?
no, we don't concede.
Okay,
We
so
don't concede.
what about the word production is Mr. Cromwell not doing?
Well, Mr. Cromwell himself did not drill a well. He didn't assign it to.
But that's not production.
Right, but the question is, so the question is, under the leases as written, they're written in the passive voice, who is supposed to do the production? Obviously, there's got to be an actor that does production. And so, because the oil's not going to produce itself, gas is not going to produce itself. And so, how do you go about determining who that actor is? And I think that this court's precedents, starting with Texas Company versus Davis, the Garcia versus King case, you look to the express purpose of the lease granting language. It's not some amorphous purpose.
So if we agree with you about that, why is his contribution to the cost of production not sufficient to mean that he is producing?
Because is produced means you drill a well or you cause the production, and that means the initial
Produce
production.
is different from drilling.
You're right, but okay, so there's a
So
distinction
you can't
between
take over, if you can't take over somebody else's lease. I mean, if somebody else has drilled a well and it's producing and for whatever reason they decide to give up the lease or it's forfeited based on some other kind of a violation and somebody else takes a new lease on that land, they didn't drill that well, but they're going to produce from it.
But they've got,
But that's not gonna hold it past the primary term?
they've got to go in and cause the production. I think they have to go in and cause the production.
It was already producing.
Right. And so
Okay,
the,
what do you mean by cause the production? Pay the expenses to get the oil out of the ground?
yes, to
Okay, but
drill
didn't he
the well, because the purpose of the lease is to exclude, they grant this land exclusively to the lessee for the purpose
Well,
of.
not really exclusively in this case,
Uh-huh.
right? Because there's a co-tenancy.
Well, but the lease granted by the Tantalos, they didn't grant a lease to Anadarko on the first instance.
Right, because maybe then the interest is or undivided, but isn't the nature of a joint tenancy that it continues on as an undivided interest? So, when you're talking about molecules from a joint tenancy, they're undivided molecules.
That's correct, but it's also.
And so do we have to think about tenancy law in the context of this lease, and how do they work together?
I think you do have to consider co-tenancy law, because the general rule is that one co-tenant does not act as an agent for another, and each is entitled to do their own drilling.
Right, but under your idea, if there were 50 joint tenants and only one was producing and the other 49 offered to participate, and the one says no, King's X, I get the entire tenancy. That doesn't seem consistent with co-tenant law either. When somebody builds or does something in connection with an undivided interest, they have the right to seek, a contribution toward the improvement. Why wouldn't that be similar? Why wouldn't that law have to overlay the lease here?
I think it does, but I think this court has made clear that if one co-tenant goes and drills a well and it's a dry hole, they can't go back and get the costs from the other co-tenants. So it's the taking.
But that's drilling, that's not production.
It's taking, but you have to take the risk to perpetuate a lease. You have to cause the initial production, which means drilling a well.
So in my hypothetical, the person who takes the second lease is not gonna be able to hold it past the primary term.
I'm not sure I understood your hypothetical.
It was somebody else drills the well, the lease expires for some reason unrelated to the fact that there's still production. And then somebody else comes in, there's already an operating well on the property and says, I want to lease that, and they do, and the well continues to produce. They didn't drill that well. But you said to me they could hold it past the primary term by continuing to cause the production from the well.
I think in that situation, you may be right, but I can't conceive of a manner where if the lease had terminated, that there wouldn't have to be some lapse in production. I mean, I don't know how the lease would terminate otherwise.
Well, there are all kinds of other things in a lease that you have to do, and maybe good operators don't violate those other clauses and cause production. But I guess what I'm not understanding is why so what's your theory about if Mr. Cromwell had entered into a JOA with Anadarko, would you say that would hold his lease?
Yes, if he entered it into because he would have shared in the costs of development and drilling the well, and Anadarko would have been nominated as the operator. Anadarko would have, in essence, been like an independent contractor hired to do drilling on behalf of Mr. Cromwell.
But there was no drilling to be done. It had already happened.
Well, there's been continued drilling on these premises. So there were three wells drilled prior to the time that Mr. Cromwell took his leases.
Sure, but he only needs the one to hold his lease, right?
Yes, Your Honor.
Okay,
Yes.
so I guess what I'm not understanding is why it matters under the JOA that there's language about him paying for drilling if he's paying for his cost to produce outside the JOA as a matter of the common law of co-tenancy. It seems like those are two different paths to holding your lease, and one is the common law and one is contractual, but I'm not understanding the distinction between the two.
If there is a distinction between development costs, which are the costs of drilling, and costs of, actually bringing the well to production in the first instance, and those are usually, very substantial costs.
Sure, and he didn't get paid anything until those had already been recouped, right?
Correct. But what he was paying were operational costs. He was paying the operational to produce. Yes, Your Honor.
Which is what the clause says.
You're correct.
Do you agree with your friend in opposition that Anadarko was a stranger to the Ferrer and Tantalo leases? Anadarko was not involved in the drafting of those, is that
Yes,
right?
yes.
And so, to use the passive voice, in your view, mistakes were made. And so you say on page 3 of the red brief, if a lessee wants to change that default rule such that production by a co-tenant or other stranger to the lease will count as production, then the lessee must incorporate express language so stating. So to Justice Busby's and Justice Bland's question, what should this lease have said to yield the result that your friend in opposition thinks? What did it need to say instead of production with passive voice?
I think it needs to expressly state that a co-tenant's production or that anyone's production would sustain the lease, because given the express granting language, the lease is being granted for the express purpose of the lessee exploring for and producing wells. And in this court's, the Davis Doctrine, in 1923, the court held that the conveyance of an oil and gas lease for the purpose of exploration and production for no other purpose, that it was a grant of a fee simple determinable, and because it was unquestionable that the land was granted and was to be used for no other purpose than to drill for and produce minerals, the grant was to be enjoyed only while the work of mineral exploration and production was carried on. And so the court held that with the title and rights conveyed by an oil and gas lease, that once it was conveyed were to be held and used for no other purpose than mineral exploration, development, and production. And when that purpose was no longer prosecuted by Underwood, the lessee and his assigns, their title and estate instantly terminated. So I think the court's holding in Davis over 100 years ago established a use it or lose it rule. A lessee has to use an oil and gas lease for its stated purpose, which is the production and exploration of oil and gas, or the estate instantly terminates. And Davis has been repeatedly reaffirmed in Rogers versus Ricane Enterprises. We quoted behind tab 5. The court clearly said Davis stands for the proposition that if the expressed purpose of a lease is the production of minerals and the grantor entirely and permanently stopped and abandoned the exploration and development of the property, then the estate terminates at once. Here, Mr. Cromwell testified that he never intended to do any development or production. Instead, he intended to use this as a passive investment because he knew Anadarko had already gone out and obtained production.
And he got a deal that's he wanted a passive investment, and his deal is phrased in the passive voice.
Correct.
I mean, is there a parallel there that you know, an advantage of their position, and it seems to me, is that, you know, if they're right, then people who have arrangements like this can just pick up their lease and read it, and it just means what it says. It's phrased in the passive voice. It doesn't require me to produce. It just requires that there is production. And so if Anadarko or whoever is over there doing a great job, then there is production, and so this continues. And that's just, you know, that's just how people would read this if you're just picking it up as a layperson and wondering what it means. Whereas your position requires people to hire a lawyer who happens to know about the case of Cromwell versus Anadarko, where the Supreme Court said that even though it's framed in the passive voice and doesn't refer to who has to do the production, it's actually you that has to do the production. And so if we're stuck between a world in which people can pick up their leases and just know exactly what they mean based on what they say, and a world in which you've got to know the case law to interpret what otherwise looks like clear English, why wouldn't we prefer what he's offering?
Well, I think you do have to include the historical context in which leases have been construed under Texas law. And make no mistake, the El Paso court here did not change the law. It didn't pull the rug out from under the oil and gas industry. They followed cases going all the way back to 1959, starting with the Fifth Circuit's decision in Madison. It was written by then Chief Justice Joseph Hutchinson of the Fifth Circuit. He was a Texas lawyer, went to the University of Texas Law School. It's not like he didn't understand Texas oil and gas law. And he wrote for the court and said that the fact that the words by the lessee did not appear after the is produced language did not mean you could rely on production of a co-tenant.
Does Madison establish that if the co-tenant is paying towards the expenses of production, that that's not enough to constitute production?
It doesn't address that issue. And then in the Hughes versus Cantwell case, which is 1976, El Paso Court of Appeals, written by Chief Justice Stephen Pressler, who I think was the chief for 40 years, he accepted the argument in Madison. In that case, the court said the stated purpose of the lease is for the drilling and producing oil and gas. And so to accomplish that purpose, the land was leased exclusively to the lessee, and it naturally follows that the intention of the parties was for the lessee to do something to bring about that production. And he could do so by drilling the well himself, or by the terms of the lease, he was allowed to assign it, or he was allowed to pool it with others and benefit from their production. And so, but the exclusive letting of the land to the lessee for the purpose of drilling and producing oil and gas acted to undercut the argument that this is produced language is sufficient to let the lessee rely on production by a co-tenant.
To the chief's question, if we could come back to the Ferrer lease, just because I think it's simpler. Paragraph 2, this lease, which is paid up lease, requiring no rentals, shall be enforced for a term of 3 years, and as long thereafter as oil, gas, or other minerals are produced from said land. And you said, and they need to say produced by the co-tenant or anyone else. Would another way of writing it so that your friend in opposition would win under your reading, could they say notwithstanding the impressive biographies of members of this court and of the Fifth Circuit and what they knew, the words in this contract mean just what a Texan would normally read the words to mean? Would that be another way to do it?
I guess so, Your Honor.
Okay.
So one thing, the other case that will become suspect if this court rules for Mr. Cromwell is this court's decision in Garcia versus King. In that case, the court was construing an habendum clause that said this lease is for a term of 10 years, and as long thereafter as oil and gas or other minerals is produced from said land. And the court held that the is produced language required production in paying quantities, even though the in paying quantities language was not included in the habendum clause. So
But there's no issue with paying quantities here. There's plenty of production.
Correct, but just as this court considered the purpose of a lease in holding that production means production in paying quantities, the court should consider the express grant of the lease to hold that the is produced language, the general rule should be that it has to be the lessee or his assignees or someone else mentioned in the lease, like someone you pool your lease with, that it has to engage in the drilling, exploration, drilling, and production of the oil and gas.
One concern that occurs to me is if we import a drilling and exploration obligation into the habendum clause, would that sort of mean that all of our precedent out there about requiring development and that sort of thing, having covenants of so that we have a lot of cases that I can't remember the exact name for this doctrine. You may know it, but if you've got thousands of acres and you've got one tiny little oil and gas well that's producing a few drops there, we have cases that say you can't just keep producing from that. There's some obligations to
the implied covenant to develop.
Thank you. The implied covenant to develop would basically be superfluous under your view of the habendum clause, right? Because you've got to have drilling and production as well. You've got to have drilling and exploration as well as production to hold the lease.
I don't think it would render it superfluous because you still would have. I mean, if you drilled one well, that would be enough to sustain the entire lease, but it wouldn't require further development. To get further development, you have to get to the implied covenant, to get to an obligation to drill additional wells.
If everybody in the industry already knows what the rules really are, why are these leases so long? So for instance, in the Tantalo lease in paragraph 2, it says, is produced in commercial paying quantities from the lands leased hereby. But if everybody already knows it, like, why do we need so many words if we're just going to say what the true purpose of them really was?
Well, I mean, oil and gas leases historically have not been the most well-written things. So I would just say, I mean, I think based on Madison, based on Hughes versus Cantwell, the established case law, that it's, and the Hornbook, I mean, the Texas Oil and Gas Treatise, which we've cited, Smith and Weaver says, ordinarily, the acts of one co-tenant to develop its lease do not serve to perpetuate the leases of other co-tenants who do not participate in the cost of development. And so I think, and they're summarizing the court's holdings in Madison, in Hughes versus Cantwell, and in Cimarex. So I think you've got to understand that Cromwell is asking this court to change the law based on what I would call a very literalistic interpretation. And Justice Comey Barrett in the Biden versus Nebraska case, which was cited, I think, in their reply brief, that talks about literalism versus context-driven interpretation. And she said, case reporters and case books brim with illustrations of why literalism, the antithesis of context-driven interpretation, falls short. Consider the classic example of a statute imposing criminal penalties on, quote, whoever drew blood in the streets. Read literally, the statute would cover a surgeon accessing a vein of a person in the street, but common sense counsels otherwise, because in the context of a criminal code, a reasonable observer would expect the term drew blood to describe a violent act. Similarly, in the context of an oil and gas lease, which has always been held to require the lessee to use the lease for the stated purpose of the grant for exploration and production, a reasonable person reading is produced would presume that the is produced language, the actor who's supposed to produce is either the lessee or his successors or assigns, or someone else who's expressly mentioned in the lease. And finally, I would just say—
To go back to the last, my question about the implied covenant to develop, it seems like that does the work to protect the lessor in this case, right? If the concern is, well, maybe he's participating in the costs of production, but he's not participating in development, then wouldn't they have a cause of action against him for violating the implied covenant to develop?
Theoretically, yes, Your Honor. I would just want to close by saying that there are implications for this court adopting Mr. Cromwell's interpretation. An oil and gas lease now would then be able to be used as a mere passive investment tool. Investors and speculators can wait on the sidelines while E&P companies go and develop and produce productive wells. They can then go find an unleased mineral owner and obtain a typical paid-up lease, and then with a clause written in the passive voice, and thereby obtain 7/8 of that lessor's minerals and leaving the lessor with only 1/8. And the co-tenants also will be disincentivized from entering into JOAs, because if one co-tenant's production perpetuates all the other co-tenants' productions, why would the other co-tenants ever agree to share in the risks and costs of development?
Any further questions? Thank you, Ms. Samora. Mr. Smith, I believe you have 5 minutes.
What about that last point that if we rule for you that co-tenants won't enter into JOAs?
I think that's ironic because Mr. Cromwell sought to enter into a JOA and Anadarko.
Right. Well, no, I understand on the facts of this case, but if we rule for you going forward, would he have offered to do that?
I think he would have, because it is incentivized by the covenants that you were discussing, Justice Busby. Not the conditions, but the covenants. And I want to discuss the implied covenants, because if the court looks back at Anadarko v. Thompson, the opinion on rehearing in that case specifically discusses the relationship between covenants and the remedies that you get for breach of that versus conditions. And the remedy for breach of an implied covenant has always been damages, or, in quote, extreme cases, a conditional decree in equity for cancellation of the lease. And the point of a conditional decree in extreme cases is that the court's decree in equity gives the party the clear, precise, and unequivocal notice that was not already set forth in the lease. So there is an established body of law regarding the remedies that are available to incentivize production or to incentivize activity by the lessee. And the parties are free to contract as they see fit. There's no need to import a default rule of the death penalty, termination of the lease, for failure to do so when there's already incentives for that. Justice Huddle, I'd like to go back to the reliance interest question that you asked about. I'd point the court to the San Antonio Court of Civil Appeals decision back in the same era in Kane versus Newman, where the San Antonio court held that because one co-tenant was producing salt from the acreage, that was sufficient to perpetuate the lease held by, the share of the lease held by the other co-tenants. We've had competing rules of law floating out there for decades, and there's the need for clarity. I don't think Madison has strong reliance interests, especially if the court looks back at secondary authorities from the time. I quoted the Williams and Myers treatise. There's a law review article by Professor Williams, the Williams and Myers. It is 34 Texas Law Review 519 from 1956. And at page 522 of that 1956 Law Review article, he makes the same point that I talked about in opening that's in his treatise today. When the parties, if the parties leave the words by the lessee out, then presumably they don't intend to require production by the lessee. And that dovetails with the question, Justice Sullivan, that you asked Anadarko's counsel about, well, what are the words that they believe should have been added to the lease? They say that we should have added the words production by anyone. We say, if they wanted their rule, that there should have been the words by the lessee. And it's exactly when a small phrase like that, by the lessee or by anyone, could have been added to the text to clarify it one way or the other. That is exactly where the clear, precise, and unequivocal rule of Anadarko v. Thompson steps in. There's not a clear, precise, and unequivocal statement that there has to be production by the lessee to sustain the lease. Therefore, it is not expired. I'd like to circle back briefly to the scope of the court's ruling. And although we would certainly welcome a victory stating that Mr. Cromwell's leases are perpetuated by the fact that he has sent checks to Anadarko, I'd caution that the result of that rule would be that Anadarko would immediately stop sending invoices to any co-tenants that it wants to ace out of the acreage. How is Mr. Cromwell to know how to participate in production, how much of a check to send if the co-tenant has the King's X to not even send the invoices? For these reasons, we ask this court to reverse.
Thank you, Mr. Smith. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.